Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as your law intellect. I hope you guys are having a very intellectual day. I see you guys are over here being legally nosy, and that is okay. Thank you guys so much for joining. If you would be so kind as to hit that like button on your way in. And if you like it over here, I would really appreciate if you would subscribe to the channel. Congratulations to all of you guys that have got the free memberships. Welcome to the Intellects. For those of you that have not joined the membership, of course, it's optional. I greatly appreciate those that have joined, but what we do, I don't come on as often as I would like because I do work full time, but I do chit chat in the membership. I post things in the membership and we comment and we interact throughout the week. And every now and then we do our own lives within the membership. So if you have not joined, I ask that you would consider joining the membership. If not, just enjoy out here. We got good content out here too. Thank you so much, Jaquai, for the Cash App. That was so kind of you. I hadn't even said a mumbling word, and you let me know you appreciate me coming on. And for that, I am grateful. That was very kind of you. I see all of you guys coming in. I missed you guys. I really, really did. Sound check. Hello. Hello, hello, hello. Thank you guys so much for coming in. We are here to talk about Ernest Williams. If you have not heard about Ernest Williams, we've been talking about him for about a year now. I think this month marks the anniversary of around my first video when it came to Ernest Williams. We have discussed everything from the marriage and his current charges that he is attempting to fight right now over there in Fulton County. He is the husband of Shirley Strawberry, who was the co-host of the Steve Harvey Morning Show. Shirley has been trying to get up out this marriage, though, and if you guys have been following, there was a hearing last week, and our girl Shirley said she wanted to get up out this marriage. And what happened was apparently the court felt that it needed to give Ernest Williams notice of the hearing. And because they had not provided the proper amount of time, which was 2 weeks, to ensure that he can be there from the actual prison, the actual jail in Cobb County, they postponed it again. And Shirley's lawyer, I have to, she did bring it to the court's attention that Ernest Williams did not respond at all. And therefore, under Georgia law, which is true, there is case law, you are not entitled to notice. However, it appears that perhaps it's the court's policy within itself to provide notice of hearings, or at least perhaps give him an opportunity by making sure transportation was available. So it sounds like they was dotting I's and crossing T's because they don't want no problems, especially since on that hearing, everybody was on there. We had the lawyer for the criminal case for Ernest Williams was on there. The investigator was on there. And then we have the person that we will be talking about today with the state's response. Will Wooten was also on there. So everybody wanted to know what was going to happen with this marriage. Okay. So yes, Shirley is still her husband. I know she was hoping next time Pam Esquire went live, she can say ex-husband. But unfortunately, I cannot say that as of yet. But a change is coming. I smell freedom for you soon, Miss Shirley Strawberry. Thank you so much for gifting a membership. I appreciate that. That was so very kind of you. And let me see what else we got. Lady Ella said, "Thank you, Pammy Pam. We appreciate all you do." Thank you, Lady Ella. Thank you guys so much for the support. That was very generous of you. I appreciate that. I'll be Huckleberry has been a member for 3 months. Thank you for your support. T Rain gifted a membership. Thank you so much. And make sure you thank T Rain for the person who received that membership. Patrina, thank you so much for the super sticker. I appreciate that. And the Real Brown Family Chronicles, thank you for becoming a member. I appreciate that. Thank you guys for all of the love and the support. Makes me have the opportunity to do what I do. So the Elite Diva said, who was supposed to give Nesto notice of appear? Under Georgia law, really nobody was. And the reasoning is because Nesto has not technically appeared in this case. Under Georgia law, if you don't respond or otherwise appear within the case, then you're not entitled to notice. They don't have to give it to you. However, apparently it sounds like Shirley's attorney gave him notice out of courtesy, but whatever notice he got wasn't enough time for the jail to prepare if he wanted to come. So the court wasn't made the decision. They didn't deny that he necessarily was not required to have notice. They didn't deny it. They just said that they wanted to give him the 2 weeks that they have so he can have the opportunity to be transported, because obviously he does not personally have the ability to just get in a car and go. So they want to make sure that that is taken care of. Dr. Pay, you guys are showing out. That is so kind of you. She gifted 20 memberships. Thank you. You just warmed my heart. Thank you so much. I appreciate that. That is so, oh, I don't know what to say. Thank you, thank you, thank you. Love to shop 1212 said, "Rush right over here when I saw your light." Thank you. I appreciate that. Hey, Ty, thank you so much for always supporting. I appreciate that. You said, "Hey, Pam, love when I catch you." I love when you catch me too, Fly Girl 787. Thank you for being a member for 6 months. I appreciate that. You guys are really showing out today. Thank you guys. Tamira became a member. Oh, my. I thank you guys so much. Make sure you guys hit the like button so other people know that we're live. You know, I don't come on enough for it to, marinate on these YouTube streets. So I want to make sure people know that we are on. So I'm going to link the video. This has been probably 2 or 3 months when there was a motion that was filed, of which Ernest Williams' lawyer wanted folk to be quiet. Okay. So what prompted this motion, aside from us talking about this on YouTube, I'm sure, and probably Nesto's friend trying to prompt this as well, that probably was part of it as well, to try to get people to be quiet, was that Will Wooten and Will Wooten is the DA who was on Nesto's RICO case, and Madam DA Fonnie Willis, they did a brief interview. And when they did this brief interview to talk about the case and the RICO indictment and all of that, bam, suddenly there was a motion for a gag order. So they want everybody to be quiet. Okay. They don't want them to talk about the case and all of that. So immediately, Dennis Byron responded to it. You guys asked me if I was going to respond. I said, I'm waiting to see what the state got to say. Shoot. I mean, I just want to see. So the state obviously did not respond to it until they had a hearing date. So right now, hey, Wisdom's daughter, good to see you, sis. So obviously, when there's a hearing date coming up September 16th of 2024. That hearing date is for this motion, which is for the gag, to prevent extrajudicial statements, I think is what they called it. So because there's a hearing date, I guess now the state is like, well, I guess I'll respond to let the court know that we are opposing this. And they have done just that. Lady, how you guys are just, y'all better hype me up. That's what I'm talking about. Make me feel good. Lady Hatanada. I know I'm saying that all wrong. Thank you for being a member for 2 months. But she said, always enjoy your content. Thank you. Thank you so much for supporting. I see y'all showing out. I appreciate all of it. I love it. Thank you guys so much. So, anyways, the state has responded. Everybody was wondering if the state was going to respond or if they didn't care and they were going to let this go. The state has responded and they are actually opposing it. You guys, thank you, Wisdom's daughter. I appreciate the super sticker. Simply Me said, I know he's too embarrassed to face her, but I would pay good money to see them both on that. So, well, you think he'll show up? I think we might have to do a poll or something to see if he would even show up. Because I think at first he was making it as if he really didn't care, so he wasn't going to show up. But perhaps because part of this is connected to his charges, he may want to show up. Because let me tell y'all something before we get into this. Shirley's lawyer. So the judge is like, why are all these people here? And I seen all y'all on there. I seen Wisdom's daughter was on there. I think Bougie, Nyla, everybody was on there. Okay, they waiting to get see. They want to report that Shirley is free. They wanted to report on that. I understand. So the judge is asking everybody on there, like, so what are you here for? Who are you here for? Why are you here? And everybody was, well, not everybody, but the majority of the people were saying they were here for the hearing for Shirley Strawberry and Ernest Williams. So Shirley's attorney said, Judge, I know you want to know why everybody's here. Let me enlighten you. So she breaks down like, part of why they're here is because part of his charges, he is currently indicted, and why he's in jail right now, the reasoning is because he's accused of marrying other women while he was married to my client. So he has that and a bunch of other issues that he has going on. And Nesto's attorney was like, oh God. He was kind of looking like, he didn't cover his face, but he was looking like, did you really have to say that? Did you really have to let the judge know that? But yeah, it was a very, very interesting Max Pop said I'll contribute $1 if he shows up. Okay. Oh my goodness. Yeah. So, and I had the video of that. And but I kept saying I was gonna go over it, but I didn't. But I know you guys seen it on the other content creators. They did it justice, talking about the actual hearing as well. Jay Vickers said, and he has a plethora of cases against and is serving in Fulton County now. He is a habitual no-show on a sure, and Shirley wants her freedom, huh? I wonder there if you could just stipulate and just say, I agree to just let her go. I mean, we don't have anything to divide. He said he don't have anything. He said that a lot of times on the jail call. So it's nothing to even talk about. We don't have any kids. Like, just let it go. Kelly said, hey, Pam, I thought the judge was asking why the criminal defense attorneys was there, and I didn't know YouTube creators could attend divorce hearings. Well, apparently they can. They asked them, the link was public, and they did ask the creators, from my understanding, they were asking them why they were there as well. But you guys can correct me if I'm wrong, but that's what I thought I heard. Rockin' Robin said Shirley's lawyers say he has a laundry list of indictment. That she did. Yes, that happened. Nesto said he didn't sign a prenup. I think he said that on one of the phone calls, right? But I don't think that matters when you're being accused of being married to someone else at the time you married them. These people in Georgia is a trip. As you guys know, we've also talked about Jennifer Williams. He wants that million. Thank you so much for that super chat. I appreciate it. We've been talking about Jennifer Williams. I'm just like, it's almost seems automatic. If you want to date in Georgia, hit that background check. Because, honey, that Jennifer Williams stuff is a mess, too. I was hoping I was going to be able to come to that, but I should at least have the video that I could show you guys the hearing tomorrow. But I know that is something that is a very interesting situation as well, with all of the alleged victims, and they've submitted statements through Simone. I think she helped a lot of them, where they've submitted statements that actually hit the docket, where they have submitted, they being those that are alleging they were victimized by Jennifer Williams' fiance, from the FBI. They have reported him to the Federal Bureau of Investigation. So yeah, I'm very, hopefully she didn't marry him in advance. Because you know how some people get married in advance and then they just go do the whole ceremony thing. So hopefully she didn't just marry him in advance. That would really suck. Secondly, I heard that they sold the wedding show. They already sold it. I don't know if that wedding gonna happen in Paris though, because the alleged victims are asking that he don't get a chance to go there unless they got some way to secure their money. Don't let him out the country unless we know he's gonna give us our money back. Thank you so much, Ivory GG, for the super sticker. You guys are showing out, and I love it. You guys, you said Jen is dumb. We'll be talking about Jen tomorrow. But yeah, Georgia is a special place, man. That is a special place. I love y'all from Georgia. Like, I hope you guys don't take offense, but you guys have some very, very interesting characters. Really, really do. You sure really said a Zoom wedding. They're going to have to do something, because if you signed a contract, see, this would be my thing. If you signed a contract that they're going to get, you're selling your rights to this and you're unable to fulfill it, would this be considered an act of God or something? Probably not, because you knew when you signed it that you was going to have to get permission and you didn't get clearance first from your PO. So I'm wondering if it's going to be some type of breach of contract, or this makes, if it doesn't go through, this is assuming that they're not able to, or he's not able to go to Paris, assuming that, we don't know what the judge is going to do. We'll know tomorrow. That if he's not able to go, then that's going to be some legal issue, because if somebody has already, they sold the rights to it, then how does that contractually go? Is there a clause for things like this to get you up out the contract? It's going to be very interesting. Oh yeah, it's a whole hot mess. This is definitely a hot mess. So, but anyway, we have really just, for like 18, I haven't been on here in a minute because I just can't stop talking to you guys. But what we are here for is to see what the state has to say. You know what, Dimples, Wimples, this was not very nice. Talking about, I'm filing a motion for Sean to find a bigger suit. That was not nice. I am ashamed right now. So let's see what the state has to say. So the state said this, and I like the beginning, okay? The state said, comes now the state of Georgia by and through the undersigned counsel, and responds in opposition to the defendant's motion for imposition of a gag order on the prosecution, counsel of the defense, potential witnesses, court personnel, members of law enforcement investigating Ernest Williams, and members of the media. That will be us. That will be us. The defendant asked the court to impose an unconstitutional prior restraint on the free speech of 3 general groups. Remember, I told you this was unconstitutional. Number 1, the media. Number 2, counsel for the parties. And 3, third parties, including witnesses, court personnel, and members of law enforcement. This was the line that gave me a little hee-hee, because I only read like one page. You know me. It says, significantly, he fails to request that the court restrain his own speech. Despite the numerous audio and video recorded statements he has made with full knowledge that those statements will be released to the public. Yep, that's what he said. That's what he said. Sound check. This. You said, "Ouch." Y'all, it's over 1,000 of you. Thank you so much. Hit the like button. Subscribe to the channel. We're just getting started here. Yeah. He said, "Well, you want us to be quiet. How about your client be quiet too? You want to ask for everybody to be quiet but yourself, I see." But anyways, nonetheless, he goes on to say the defendant cites to no law in support of his position and points to no facts demonstrating even a reasonable likelihood of prejudice. Instead, his motion is based on his merely speculative conclusion based on no evidence that the quote inordinate amount of publicity that has been given and will be given to this case, end quote, will deny his quote right to a fair trial and impartial jury, end quote. If the courts were to grant the defendant's motion for a gag order, such an order would amount to a presumptively unconstitutional prior restraint on free speech and publication, which the Supreme Court of Georgia has categorized as, quote, the most serious and the least tolerable infringement on our First Amendment right. And that is WXIA TV versus State of Georgia. And it's 303 Georgia 428. Because, we like our authority over here. We don't just say stuff. We try to get the case law or the statute to support it. Then they go on and they say, for the reasons set forth below, the defendant's motion for a presumptively unconstitutional prior restraint on free speech and free press should be denied in its entirety. See, that's why I knew I ain't have to say nothing. I said the state got this. The state's gonna handle this. Thank you, Tam Jam, for the Cash App, and Valerie and Nathaniel. Thank you so much for the Cash App. I appreciate that. That was Kelly. Thank you, Kelly. I appreciate it. She said she used her man's Cash App. I thank you. Thank you to your man for letting you use the Cash App. We appreciate it over here. She got the note in her Cash App. Like, I need you to know who this is. I appreciate your support, Kelly. So let's go to the first point. The defendant's motion for a presumptively unconstitutional prior restraint on speech in the press and is not sustained by any standard, even, quote, the most differential considered by the Supreme Court's Georgia and WXIE TV. So that is the heading. So let's learn some constitutional law right here, okay? We're about to learn about this here First Amendment. The First Amendment provides that, quote, Congress shall make no law abridging the freedom of speech. And y'all go pull out your U.S. Constitution, because that is in the First Amendment. And it is no longer open to doubt that the liberty of the press and of speech is within the liberty safeguarded by the due process clause of the 14th Amendment from invasion by state action. That is the Nebraska Press Association, and that is the United States Supreme Court, the highest court of this here land of 1976. The Supreme Court of the United States has interpreted these guarantees to afford special protection against court orders that prohibit the publication or broadcast of particular information or commentary, orders that impose a previous or prior restraint on speech. Recognizing this, the Supreme Court of Georgia has held that gag orders of the type requested by the defendant are prior restraints on free speech, and as such, quote, they are presumptively, end quote, unconstitutional. So you're trying to infringe on our constitutional rights when you requested this. Let me see. What does this say? Let me see what this number one is a footnote. I'm trying to see what it's connected to. So there's a footnote that just says the 2005 disappearance. I must talk about what the case is about. The 2005 disappearance of Grinstead, a teacher and former Miss Georgia pageant contestant, attracted significant media attention, both the local and national level. The case was featured on television shows such as 48 Hours and Nancy Grace. The present case, by contrast, has received significantly less media coverage, consisting mostly of a few local news stories and regular commentary by individual content creators on YouTube and similar platforms. We have been recognized, YouTube. We have been recognized in the pleadings, all you YouTubers. In WXIA-TV, the Supreme Court vacated an unconstitutional gag order issued by a trial court in a high-profile murder prosecution related to the disappearance of Tara Greenstead. So that's what I just read. That prohibited counsel for the parties and their offices, a defendant and their counsel in a related case, court staff, and members of law enforcement from making any extrajudicial statements by any means of public communication and news media concerning 1, the character, credibility, reputation, or criminal record of the defendant; 2, the identity of a witness or their expected testimony; 3, the possibility of a guilty plea; 4, the existence or content of any admissions or statements by the defendant; 5, the performance or results of any tests or examinations; 6, the identity and nature of physical evidence in this case; 7, any opinion as to the defendant's guilt; or 7, any, they got 2 sevens, okay. Another 7, any information that the lawyers know or reasonably should know is likely to be inadmissible as evidence at trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. So this is what they were asking in this case, that this WX, this news station, basically appealed the judge allowing this order that would prevent all of these numbers that we just read, 1 through 7, because there's 2 sevens. While far-reaching, the gag order held to be unconstitutional, and WXIA-TV was nowhere near as sweeping as the order requested by the defendant in this case. The WXIA-TV gag order did not apply to all potential witnesses, but instead only to law enforcement who participated in or had knowledge of the investigation. It did not forbid all extrajudicial public statements about the case, but only those on certain enumerated topics. It specifically allowed public extrajudicial statements concerning 1, the defendant's identity, age, residence, occupation, and family status; 2, requests for the public's assistance in obtaining evidence; 3, information contained in public records or subject to disclosure through open records requests; 4, the claim, offense, or defense involved; 5, circumstances surrounding the defendant's arrest; 6, the identities of investigating and arresting officers or agencies and lengths of their investigation; 7, the scheduling or result of any judicial proceedings; and 8, information as permitted by Georgia Rule of Professional Conduct. The order also specifically stated that it was not a restraint upon speech by members of the media or other members of the public. Still, even with limits on the classes of person to whom the order applied, numerous content-based exemptions, and specific exclusions to the press and the public, the gag order was held unconstitutional. So basically, in this case that the state is referring to, they were asking for even less restraints than what the attorney and Ernest Williams is asking for in this original motion for a gag order. The court held in WXIA that even their less restraints was unconstitutional. So what the state is saying is that certainly if it was not even the same amount of restraints in WXIE of the freedom of speech, and the court said that was unconstitutional, it's definitely unconstitutional with what the defendant is asking for, because he's asking for way more. The court examined the gag order under multiple standards of review, including under an exacting standard set forth in Nebraska and under a more deferential standard set forth in Gentile. So it's telling you the test that the court used before it came to this decision. Ultimately, the court declined to decide definitively the proper standard to apply, and instead found that even under the most deferential standard, the evidence of record and finding of the Superior Court could not sustain the modified gag order. The court held that at minimum, there must be, quote, a reasonable likelihood of prejudice to justify a gag order, and a quote reasonable likelihood of prejudice sufficient to justify a gag order cannot simply be inferred from the mere fact that there has been significant media interest in a case. After all, pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. And in the overwhelming majority of criminal trials, pretrial publicity presents few unmanageable threats to the right to a trial by an impartial jury. And while this court did not definitively adopt the standards set forth in Nebraska, it noted that, quote, we think that a prudent trial judge would at least consider the standard described in Nebraska press before issuing a gag order. So now we know what the standard is. That's what I just read. And now the state goes into this case, which is the Williams case. And he says here, the defendant asked the court to impose a gag order that is far more sweeping and comprehensive than the gag order held unconstitutional in WXIA-TV. Ain't that what I just said, guys? That's what they were saying? The requested order cannot pass constitutional muster. The defendant seeks to prohibit the media, counsel for the parties, and third-party trial participants, including all, quote, potential witnesses, from, quote, making any statement about or releasing information concerning the within case by any individual or entity, including but not limited to radio, television, social media, podcasts, the internet, or newspaper reporters, end quote, until the final disposition of the case. So he don't want us to talk till this case is over. Boiled down, the defendant asked the court to forbid any person who has any chance, however slight, of being called as a witness in this case, from Steve Harvey to the custodian of records for Wildcat RV sales in Corbin, Kentucky, from making any statements, public or private, about the case to any other individual or entity under any circumstance. Such an unconstitutionally broad order, absent even a mediocre, I can't even say the word, modicum of evidence that supports a reasonable likelihood of prejudice to the defendant, cannot be granted. So that is their general reasoning. You said Wooten is not playing. Steve ain't thinking about that stuff. He did. The unconstitutional gag order requested by the defendant would prevent members of the DA's office from discussing the case with victims, witnesses, and law enforcement, and would prohibit even internal discussions. He said this gag order would make it where we can't even talk to the victims. We can't even discuss it with ourselves. Like, this is how broad this gag order request is. The defendant's motion asked the court to enter an order prohibiting, quote, counsel for the state from making any statements about or release information concerning the within case to any individual or entity. This broad request is problematic for several reasons. First, both the Georgia Constitution and Georgia's Crime Victims Bill of Rights require the state to release certain information to crime victims. The Georgia Constitution established several specific rights to victims of felony property crimes like those alleged in this indictment in this here case. When the crime is one against or involving the person of the victim or is a felony property crime, such victims shall be afforded the following specific rights. The right upon request of reasonable, accurate, and timely notice of any scheduled court proceedings involve the alleged act or changes to the scheduling of such proceedings. The right upon request of reasonable, accurate, and timely notice of the arrest, release, or escape of the accused. The right not to be excluded from any scheduled court proceeding involving the alleged acts. The right upon request to be heard at any scheduled court proceeding involving the release, plea, or sentence of the accused, and the right to be informed of his or her rights. So these are all the rights of the victim. So based on what he's asking, the state is saying, listen, what you're saying, we can't even talk to our victims and follow what they have the right to know. So then the Georgia Constitution, the Georgia Statutory Crime Bills of Rights also requires the state to notify victims of certain information, including one, the defendant's arrest, two, the defendant's release from custody, three, any judicial proceedings at which the release of the defendant may be considered, four, any escape by the defendant and a subsequent rearrest, five, violations of conditions of release if the defendant is released from custody, six, the possibility of pretrial release. Seven, the victim's rights and role in each stage of the criminal justice process. Eight, the means by which additional information can be obtained. Nine, the availability of victim compensation. 10, the availability of victim service programs. 11, procedural steps and process in the case, including the right of restitution. And 12, suggested procedures if a victim is subject to threats or intimidation. The defendant seeks an order that would bar all of the above communications in violation of Georgia Constitution and multiple statutes. Whew. Moreover, the defendant's requested gag order would prohibit the state from discussing this case with any witness, law enforcement officer, and virtually any other individual or entity related to the case until the matter is disposed. As requested, such gag order would even prevent DA's office staff members from discussing the case internally. In WXIA TV, the Supreme Court of Georgia commented that it may be constitutionally permissible to regulate extrajudicial speech of lawyers so long as the regulation is designed to protect the integrity and fairness of a state's judicial system, and it imposes only narrow and necessary limitations on lawyer speech. But the gag order requested by the defendant clearly goes far beyond a narrow and necessary limitation on speech. Such a gag order would not only not protect the integrity or fairness of Georgia's judicial system, but it would fly directly in the face of the integrity and fairness by crippling the state's ability to prosecute this case. The defendant's request must be denied. Everybody put denied in the chat. Denied, denied, denied. That's what he said. Let's go on. Sub B. Unlike in WXIA TV, the standard set forth in Nebraska Press applies here, in part because the defendant seeks a prior restraint on the press. In WXIA TV, the court distinguished Nebraska Press on one significant ground. Nebraska Press concerned a prior restraint of the media, while the media was specifically excluded from the gag order at issue in WXIA TV. The same cannot be said here, where the defendant explicitly asked the court to gag, quote, members of the media, including radio, television, social media, podcasts, the internet, and newspaper reporters. Nebraska Press is, at least to the extent that the defendant seeks to gag the press, entirely applicable here. In Nebraska Press, a trial court prohibited members of the press covering a high-profile murder prosecution from reporting on three matters. A, the existence and nature of any confession or admission made by the defendant to law enforcement officers. B, any confessions or admissions made by any third parties except members of the press. And C, other facts strongly implicative or of the accused. And that's in 427 U.S. at 545. The Supreme Court treated the gag order as a prior restraint and indulged a heavy presumption against its constitutional validity. And it ultimately concluded that the gag order was not sustained by the record. In reaching that conclusion, the court held three factors must be considered. Number one, the nature and extent of the pretrial news coverage. Two, whether other less restrictive measures would be likely to mitigate the effect of unrestrained pretrial publicity. And three, how effectively a gag order would prevent any threatened danger. A court must then consider whether the record supports the entry of a prior restraint on publication, one of the most extraordinary remedies known to our jurisprudence. Interpreting Nebraska Press, the Supreme Court of Georgia further explained, a prior restraint is permissible only if narrowly tailored to avoid a clear and present danger or serious and imminent threat to a competing protected interest, and only to the extent that no alternatives less restrictive than a prior restraint are reasonably available. For those of you that don't know, a prior restraint is stopping you from doing something before you even do it. That's basically what they're saying. So you're trying to prevent people from being able to talk, including the media, the DA, before they even said anything, basically. This is usually also a defense when people do defamation lawsuits and they want them to not say their name again. Don't say this ever. Don't talk about my baby. Don't talk about my mama. Don't talk about that. That is a violation of prior restraints of your First Amendment. That's a First Amendment violation. Let's go on. Without examining the other two factors in this case, the defendant's position crumbles. With respect to a whether alternatives less restrictive than a prior restraint are reasonably available to mitigate the effects of pretrial publicity. There are numerous less restrictive measures that would mitigate any potential effects of pretrial publicity in this case. Number one, searching, questioning of prospective jurors to screen out those with fixed opinions as guilt or innocent during voir dire. So basically, a way that you can mitigate any potential effects of pretrial publicity is when you go to a juror, this is what his attorney should do. Juror number 7. Do you watch YouTube? Do you? Have you heard of Shirley Strawberry? Do you watch Pam Esquire, the Law Intellects? Do you watch are you a Bougie Gang member? Your Honor, I would ask that this juror be struck because they watch all their stuff over there on YouTube. And I think it might be prejudicial. Then you get the people that's like, huh? I've never watched YouTube a day in my life. You know. That's what they mean doing voir dire when you question the jurors before you pick your jury. Number 2. Right. Do you watch phone calls? Have you heard of phone calls from prison? How many on this jury watch phone calls from prison? Everybody be like, that's how you do it. You just ask specific questions related to what they know. All righty. Number 2, the use of emphatic and clear jury instructions on the sworn duty of each juror to decide the issue only on evidence presented in court. So basically, when you do your jury instructions, you say, ladies and gentlemen of the jury, despite whatever you heard outside of here, or even those things that I told you to disregard that you guys have heard during the course of this trial, you cannot consider that when you guys deliberate. The only thing that you can consider is what has been admitted as into evidence. So anything that we have sustained objections, if I say strike it, you can't, or any outside influence, you cannot, when you deliberate, you cannot consider that. So even if it was some outburst in the gallery where they said he did it, we instruct you that you cannot consider that when you do your deliberation. So that's what happens with when you do your jury instructions. Those are when they'll say, like, lawyers, what the lawyers say is not evidence. So even though they're trying to persuade you in their closing or their opening, what they say is not evidence. The only thing that is evidence is what the court has deemed admissible in this case. You said you can't wait for this trial. Are you guys hitting that like button? It's a whole lot of pages on here. I didn't know it was this long. Make sure you hit that like button, please. I appreciate that. Number 3, the third thing you can do is jury sequestration. Y'all know what it is. This is when oftentimes they'll tell you, you cannot, like on the YSL, they'll tell the jurors, do not read the paper, do not listen to the radio, do not watch, don't stay on social media, don't have a conversation with other people. You're basically sequestered. In some cases, I think like the O.J. Simpson case, they'll have you stay in a hotel. And they'll actually restrict, like you can't watch TV or anything. Your family and your friends right now are these jurors, and that's it. And they'll make sure that you're away. But sequestration, And sequestration also occurs during trial. So you can say, Your Honor, I would ask for sequestration for any witnesses, which basically means if there are witnesses that are in the gallery, in the area where you observe the trial, if they are going to be a witness, you cannot hear the testimony of whoever is testifying, because we want to make sure your testimony is not influenced. So until you actually testify, you cannot come back. You cannot sit in the gallery and watch the trial, even if you are interested in the trial. That's what sequestration is, for those of you that don't know. Let's go. Number 4, a change of venue. You can say, listen, Fulton County ain't where it's at because this is just too much publicity. And you can try to do a motion for change of venue to have it go to someplace else. There's a whole lot of counties out there in Georgia. Number 5, postponement of the trial to allow public attention to subside. So you can also just wait to have the trial and I guess see if everything after a while it dies down. Like you'll see, it's not as much traffic when it comes to this case. You'll have things such as when Shirley gets the divorce. We're really going to talk about that portion of it anymore as much. But when we're going through the process and we're reading all the documents, of course, we're going to be talking about the case like we just did at the beginning of this video. If you guys followed me with Bishop Lamar Whitehead, once he went to prison, we ain't really been talking about him. Sometimes things just die down after a while. So they're saying, we can just wait for things to die down too. But the point was, there are so many different ways that are less restrictive in order to mitigate any potential effects of pretrial publicity. And you haven't, at least try those before you talking about being unconstitutional and violating constitutional rights by placing gag orders on folks. Then he goes on and says, while the state in no way concedes that any of these alternatives other than effective voir dire and jury instructions are necessary at this point in this case, their mere existence serves to defeat the defendant's position. So what the state is reiterating, that they don't believe that any of these things, aside from proper voir dire questions to make sure that the jury is not influenced or doesn't have already have a position where they believe that he's guilty or not guilty based on the pretrial publicity. That's the only thing that the state says is required in this case, which is usually done in every case anyway. So they're not conceding that any of these other numbers that's on here regarding change of venue and sequestration and all of that and postponement is necessary. But their point was, you're trying to gag people before these alternatives are even explored or considered. Any consequences of pretrial publicity in this case can be effectively remedied through questioning, through thorough questioning during jury selection and through jury instruction. The defendant fails to point to any facts, arguments, or legal authority that support any other conclusion. So then the DA has point 2 where he says any extrajudicial statements previously made by the state in this matter are authorized by the Georgia Rules of Professional Conduct. The state has given one interview about this case to the media, and then they tell you where to go. See Ashley Lincoln, husband of Steve Harvey Morning Show co-host, indicted on RICO charges in Fulton County, which was May 31st of 2024, and gives the link for the court to refer so they can see what they said. All of the statements made in that interview are specifically authorized by the Georgia Rules of Professional Conduct. While the rules do not bind what this court can or cannot do, they provide guidelines approved by the state court of Georgia as to what statements can appropriately be made by parties to a criminal action, including prosecutors. Beginning with Rule 3.8 sub G, prosecutors are specifically authorized to make extrajudicial public statements, quote, that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purposes, end quote. The comments, let me see. The comment further explains that nothing in Rule 3.8 is intended to restrict the statements which a prosecutor may make, which comply with the Rule 3.6 regarding pretrial publicity. And then, there's also a long footnote that we're going to read. And the state talks about the public statement that was actually made in that link. The public statements made by the state were as follows. Number one, he's been conning people from 2009 to 2022. Number two, the big picture is that Ernest Williams is a con man. End quote. Number three, he would pretend to be a legitimate businessman, but he was stealing from people, United States currency, vehicles, and really just taking advantage of people. End quote. Number four, he would create this impression of some level of success and use that to scam other people. Number five, Ernest Williams created this impression of a close relationship or romantic relationship with many of these victims and used these relationships to take money, vehicles, vehicle trailers, RVs, and other property from them. The sixth thing that they said, we believe that Shirley Strawberry met a man, fell in love, and married him. And the truth is, at the time, he was already married to someone else. And number seven, he was married at the time that he married Shirley Strawberry. They said that's all we said. They said that's all we said. Y'all okay over there in the chat? That's what they said in the thing. They put all their quotes out there in the footnote. Let's go on. Rule 3.6 provides that a lawyer who is participating in the investigation or litigation of a matter shall not make any extrajudicial statements that a person will reasonably believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. And that's the Georgia Rules of Professional Conduct, Rule 3.6. And it has in the comments explain that certain subjects are more likely than not to have, quote, no material prejudicial effect on the proceeding, and advises that a lawyer, including a prosecutor, may usually state, one, the claim, offense, or defense involved, two, information contained in a public record, three, that an investigation of the matter is in progress, number four, the scheduling or result of any step in litigation, five, a request for assistance in obtaining evidence and information necessary thereto, six, a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. Seven, the identity, residence, occupation, and family status of the accused. Number eight, information necessary to aid in the apprehension of that person, the fact, time, and place of arrest. And 10, the identity of investigating and arresting officers or agencies and the length of the investigation. The comment to Rule 3.6 further provides that extrajudicial statements that might otherwise raise a question under this rule may be permissible when they are made in response to statements made publicly by another party, where a reasonable lawyer would believe a public response is required in order to mitigate potential prejudice. As explained in more detail below, the defendant gave a video recorded interview while incarcerated at Cobb County Jail to YouTube blogger Sylvia Tumasimi. Girl, you done made the brief again. Girl, you done made the document again. saying up in these dang on court documents? Let me be quiet because I ain't read it all. Shoot, I might be in this document too. Oh, Jesus. Mm, 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 mm. See, Sonya, this is where I can't. I said this, and you guys have been following me since the beginning. And this is what one of the reasons why Sonya did not like me. You are not helping him, trying to push him to do these interviews. I said that over and over again. Don't litigate in the media. I know, trust me, it sucks when people talk about you. When they said things that are not true, I hear it a lot on YouTube about myself. And it takes everything in me, the power of God, not to go do some clapback videos. But everything does not have to be litigated on this here internet. You have an active court case. The best advice that Ernest Williams got was his son Dion telling him what it was. That's just that. But anyways, let's go. Oh, the interview was posted publicly to YouTube on April 26, 2024, just 3 days after the defendant was indicted in this case. During the interview, the defendant made multiple public statements about this case. The only public statements made by the state in this case occurred on or about May 31st, 2024, which was after the defendant's interview was published to YouTube. The state's statements were necessary to inform the public of the nature and extent of the indictment and served a legitimate law enforcement purpose. As was authorized under Rule 3.6, because they were made for the purpose of seeking out other potential victims and inviting them to come forward. The statements were also limited to subjects which are more likely than not to have no material prejudicial effect on the proceeding as authorized in Rule 3.8, including the offense involved and the identity of the persons involved, information contained in the indictment, and requests for assistance in obtaining evidence and information necessary thereto. None of the statements reveal any more information than what is alleged in text of the indictment. So then they said, let's go. Come on, Judge. Come on, let's read part of the indictment so you can see why I said what I said. Let's see. Hey, PCP, thank you so much for popping in. We appreciate you. Let's mosey on down to this indictment and see what the indictment said. It says from at least December 1st, 2009 through June 30th of 2022, Ernest Williams engaged in a pattern of racketeering activity in Fulton County, Georgia, elsewhere in the state of Georgia and other states. The RICO scheme was designed to defraud unsuspecting individuals, businesses, and governmental entities with the primary purpose of depriving numerous victims of their property. Williams stole United States currency, personal vehicles, motorcycles, coach buses, trailers, automobile parts, and other various services and property, often by falsely promising to help his victims engage in new business ventures, to promote their existing business ventures, or to help them build their brand or image. Many of Williams' victims were women, and Williams often used the illusion of romantic or close personal relationships with those victims to manipulate them and to steal from them. As part of the scheme, Williams knowingly entered into a fraudulent marriage with Shirley Strawberry, a famous radio show. Indictment at 7. And the grand juror aforesaid in the name and behalf of the citizen of Georgia do hereby charge and accuse Ernest Williams with the offense of bigamy for the said accused in Fulton County, Georgia, on or about January 9th, unlawfully while being married to Martha, and knowingly that his lawful spouse was living married Shirley Clark Strawberry and carried on a bigamous cohabitation with Shirley Clark Strawberry. And that's over there at indictment at 22. Okay. Got to take one brief pause for a second. Hold on. Y'all talk amongst yourselves. I'll be back in 1 second. Sorry about that. Make sure you guys are okay over here in this here chat. Fulton County loves to throw RICO charges on people. That they do. Yep, they do. Let's move on. 504 said this feels like Christmas. Okay, let's go. Hold on 1 second. Moreover, in advance of those public statements, several emails, including a draft press release, were exchanged to ensure that any public statements made related to the case complied with Rule 3.6 and 3.8, Exhibit A. And they got emails from Will Wooten to Jeff DeSantis dated April 25th, 2024 and May 1st. In particular, the April 25th email states, the body of this presser is largely pulled from the indictment itself. So if possible, please give me a heads up if anything there needs to be changed. Want to make sure it doesn't include anything that's not in the indictment itself. The draft press release includes the statements, quote, members of the public who believe they may also be victims of Williams related to the scheme are encouraged to immediately contact Fulton County DA's office. And then it gives the email address, and defendants charged by a grand jury are presumed innocent until proven guilty beyond a reasonable doubt in a court of law. The May 1st email also states, we like to get this out to the press ASAP so we can get the FCDA fraud tips out to the public and hopefully have some more victims come forward. So there was also a press release of which it looks like he got permission. He had it looked over before he even sent it out. So he was very careful to make sure that it complied. Accordingly, any public statements made by the state related to this case were explicitly authorized by the Georgia Rules of Professional Conduct, Rules 3.6 and 3.8, and they were made for a legitimate law enforcement purpose. In light of the guidelines provided, these statements are not grounds for the issuance of a gag order on the state. The third part here says the defendant fails to ask the court to impose a gag order on himself. And he has made multiple public statements since being indicted of the same character that he now asked the court to restrain others from making. That's what I'm talking about right there. That's what I'm talking about. Finally, as referenced above, the state must point out that the defendant himself has made multiple public statements regarding the facts of this case. Significantly, his request for a gag order does not include himself as one of the parties to be gagged. Although he remains incarcerated, many of his recorded telephone calls made from Cobb County Jail have been publicly released on YouTube and other platforms. The defendant is aware of this fact, and he has on multiple occasions intentionally made recorded statements with knowledge and intent that they will be published for the public to view on YouTube. As an example, on or about April 26, 2024, the defendant gave a video recorded interview to YouTuber blogger Sylvia. Girl, you ain't here again. Also known as infamous Sylvia, discussing the facts of both this case and other cases pending against him. And then they have the link. She gonna get some traffic. It was from April 26th of 2024. The defendant made multiple prejudicial statements against the state, and Rule 3.6 authorized the state to respond. At the time of the filing, the hour-long video recorded interview was received more than 11,000 views. Several excerpts from the interview with the timestamps are provided below. And they have excerpts of the interview on here. And it has Tumasimi. So, how are you feeling about what happened a couple of weeks ago? Referring to the preliminary hearing that occurred on April 8, 2024 in Fulton Superior Court. We hadn't talked about that. How are you feeling about that? Williams said, well, how should I feel? You know, they've been doing the same thing, lying. So, I mean, I can't make this stuff up. I can't tell somebody, hey man, do this, check this out. People want to believe what they want to believe. And they gonna make up what they want to make up. So it's clear. I mean, just clear. It's just clear. I don't have no 14-year-old daughter. Timossini. You don't have a 14-year-old daughter in 2022? Williams. No, come on. Everybody know that. Tumasimi. What about your grandchild? Is your grandchild was 14 at the time? Williams. I ain't see my grandchild in 2022 years old. Didn't you just see me in the graduation with her in 20? I don't have all that going on. All that stuff is just fluff. You know how you charged me with the same charge 15 months ago. Okay, 15 months ago, you charged me with the same exact charge. Ain't doing nothing but change the date on it and start me all over again. That's all it was. Then they got infamous Sylvia video visit with Ernest Williams after the divorce was filed. At timestamp 9 minutes and 8 seconds. Lord have mercy. Here's Williams. See, here's the thing. You got to stay strong through your trials and tribulations. You can't sit down with somebody and say, hey, man, don't do that. Don't do this, you know? And they say, well, how you know? You don't know what I'm going through. Well, if I went through some things, I should be able to tell you some things. But if I don't go through nothing, I can't explain nothing. Correct? Trust me, I'm going to win at the end. I know I am. They underline that. So sometimes people have to do what they think is best for them at the time in the moment, okay? I've seen it time and time again. So you can't fault nobody trying to do what they trying to do for themselves. Life is too short to be sitting around trying to wonder, wishing, hoping, disagreeing, and arguing. Do what you got to do. Hold on one second. Then they got infamous Sylvia video visit with Ernest Williams after divorce filed at 10:05. What do you say to the people that's saying you're getting your karma for the things you've done? What do you say to those people? Williams said, hold up. I don't know them people. Don't entertain them people. I can't see what people say about me. I can't see what people disagree about me. I don't see any of that. I don't see it. It's not around me unless somebody like yourself tell me. You know, I might hear it then, but I don't want to see it. I don't really entertain it because I don't have nothing to entertain. Tumasini. Well, what would you say if you were, what would you say? William said, well, first of all, I don't believe in karma. I don't believe in it. That's an old Chinese thing. I don't believe in all that, okay? You can have a 5-year-old child walk across the street and get ran over. You can have a 5-year-old child looking at the TV, minding their own business, playing with their toys, and stray bullet come through and kill them. You can have a dog just try to walk across the street, okay, trying to find somewhere it's going, get ran over. You can have a stray deer in the night get ran over by an 18-wheeler. Is that karma? That's not karma. That's just the way of life. So here's the thing. Here's the thing. I'm gonna win at the end. Trust me. I'm gonna win at the end of this journey, and I'm going through right now. I'm gonna win. Sometimes, people will put in your ear. You gotta watch who you pray with. People praying on your downfall. You get me? You get what I'm saying? Okay, he didn't say that part. That's what I said. Tumasimi said, Amen. Amen. Then William said, they praying on your downfall. Tumasimi said, Amen. Then William said, so you know what I say to that? Hey, we all human. We all human, and we do things, say things out of character. And sometimes we do things intentionally to make sure, not for their own well-being, their own wealth or gain or whatever. Sometimes they can't help but say what they have to say. It just comes out. So whatever people say about me, it don't matter to me. Because guess what? At the end of the day, I gotta be happy with me. I can't be happy with nobody else talk about. Y'all better be hitting this like. Y'all got me over here working. I gotta be Sylvia today. I gotta be Eric. I gotta be Ernest Williams today. I gotta be Wooten. Y'all hit this like button. Subscribe to the channel. Hit them cash apps. Hit them hit these super chats. Thank y'all so much. H. Sherry said this man is definitely delusional. Thank you so much, Phone Calls from Prison, for gifting the 5 memberships. I appreciate that. 504, here we go. Hey, Pat, the next time you run into Erica, can you please ask her if I can have her oxygen tank that she is a user, the one that wasn't plugged in? Only 504. Leave that lady alone. She done played. She trying to move on with her life. Muffin, thank you for the super chat. Said, what up, though, Pammy Pam? Love your content. Thank you so much for the super chat. T Rain, thank you for the super sticker, hun. I appreciate that. That is so kind of you. Sexy RN said, CCRN said, how this man allow himself to be conned by a woman that cannot even hold her afford health care outside of the ED visits and who is allegedly living off of low SS checks. I don't know. I'm just reading the documents. Thank you, Always Loving Life, for being a member for 3 months. Praise y'all said, paying it forward to our attorney of law and order, Pam Esquire. Thank you to the intellects for the gift. Thank you so much. I appreciate that. Who else I miss here? Jackson Tabasco, thank you so much for the super chat. You said Nestor and his renter center attorney don't stand a chance. His attorney is a good attorney, from my understanding. We're not going to talk about his attorney. He all right, from what I hear. 101, thank you for being a member for 5 months. She said, career criminal trying to outsmart from behind the bars. He said they want all the foolishness out here. Okay. Think that's all of them. Thank you so much. Real Talk Red, I appreciate you for being a member for 3 months. You said, love your content and you look beautiful tonight. But thank you. Thank you for hyping up your girl. I appreciate it. So let's go on. We at our amen. I think we are on the 4th clip, which was at 26 minutes. And this is infamous Sylvia video visit with Ernest after the divorce. Williams said, I got a question for you. So let's see, it's going on 5 months now. I've been knowing you almost 5 months since January. What do you think is going on? Your personal Tuma Seaman. Personally, from what I've seen and what I have read and all, it's not matching up for me. They underline hers too. It's not matching up at all. And I dig, and well, you don't know it, but I dig, and use I use common sense too. I use common sense. Stuff is not matching to me. So therefore, if it, like the OJ Simpson thing say, if the glove don't fit, you must have quit. I did not watch any of these videos. I am literally hearing all these statements for the first time. And I don't even know what to say. I don't. I talk for a living. I don't know what to say right now. If people, so I'm this just a little, we're gonna put a pin in here right quick. There's an issue that I did see. There was some videos that apparently, I guess, this person is having some issues with people that have, well, at least one person has written a letter to a judge and basically complained about all of this and about this person getting close to these people. How do you not look at these transcripts of this stuff and these videos, and it does not look like evidence for what people are saying is happening? How do we say we're media, but then we go and we try to get chummy with different individuals? How do you not see that it's going to come back to get you in these pleadings and stuff? I don't know. I try to stay out of it because I don't got nothing against the lady, and I don't never want to look like I'm a part of any bullying or picking on like I was accused on before, because that's not even how I roll. But sometimes we just got to use wisdom. And all I get thy understanding, and all the praying and amens, let us pray for wisdom. 504 said all she had to do was keep her prayers to herself. Thank you for the super chat, sis. I appreciate that. This stuff is unbelievable to me. And then you sit there like everybody's hating on me. Girl, do you see this type of stuff? Hating on what? Do you see this type of stuff? Like the perception that is being put out there? Everybody wants to get one leg up on the next person. Like, we are all content creators, and we do our content in different fashions and different ways, and a lot of our stuff does overlapping, but what I give is not what the next person give. What phone calls from prison gives is not what I give, but it all is a different way of doing commentary and different perspectives. But sometimes it's like survival of the fittest on these YouTube streets, and it just is not that deep. But anyways, I see your super chat and I appreciate it. Thank you so much. M. Sear said, this is pure gold. So glad I'm here for this. You're the GOAT, Pammy Pam. Thank you. I appreciate that. Patty said, it's just her trials and tribulations. It's just a setback for the comeback. Well, bless her heart. And thank you for the super chat. Everybody hating people like you're giving them material to hate on you with. If we want to call it hating, you are giving them nice prime material for it, though. That's all I'm saying. Anyway, let's go on. William said, oh, okay. Tumasini said, in honor of OJ Simpson. That's it. William said, no, I understand. I understand. I understand. I mean, it's not matching up. So yeah, I'm not saying that you don't have a past now. You do have a past now. I'm not going to try to sugarcoat that. Williams, hold up. I got a past from 32 years ago. He checked her. He was like, hold on. I know. People change. Yes. Okay. I know, right? Williams said, I've done a lot of great things since then. A lot of people don't never change, never do nothing good, okay? I've done a lot of good things, and I'm not going to let nobody take that away from me. You see what I'm saying? I knew that was coming. Sylvia said, well, tell them. Tell it. Tell you're good. Tell your good stuff. Tell it. William said, I'm just saying I have because I've did a lot of pat yourself on the back. Huh? Pat yourself on the back. Yeah. I mean, sometimes we can forget that. We can forget that because of the discouraging things. Then they got a timestamp at 27 minutes and 50 seconds. Oh, Lord Jesus. Thank you, Courtney, for the Cash App. I appreciate it. William said, the things you go through in life make you forget those great times and good things and good energy that you put out, because there's so much bad energy they're working towards you. You know how it feels to sit up there chained up with this orange on. You know how that feel, but you ain't sitting in that courtroom and you seeing them white boys sitting up there in them police uniforms looking like they want to hang me on a tree. Whoa. That was underlined. So that was something that the state wanted to point out to the court. See, I've never felt that in my life, but I felt it that day 2 weeks ago. When I tell y'all what, that's not a good feeling. You know what I'm saying? I've never felt like that as a black man. But when I saw that and my mouth is shut and I can really defend for myself, I felt that, okay? And for them people getting up on that stand like that, telling them lies the way they tell them, and I can't say anything, that was underlined. Guess what? I had to remind myself it's just a preliminary hearing. It's not a trial. You understand what I'm saying? So sometimes you got to sit back and think. Now you can't get tricked, but a lot of people are using this to make money off of me, making a career off of me, and just make something to have a conversation about. Okay, and I understand that. I understand. But we're in another world right now. If I wasn't who I was used to deal with in the past, I'ma say that you would never see me on no TV. You would never see me on no internet. We wouldn't be doing no visit calls and all that. None of this wouldn't be important to nobody out there. Am I wrong? This was at 30 minutes and 50 seconds. William said, I ain't going to prison. I promise you that. Absolutely, I know that for a fact. Trust me. That was underlined, as you see from the states. Woo, Sheila 928. Thank you for being a member for 7 months. She said, this is better than an audiobook. You better read. Thank you. Thank you, sis. I didn't expect I was gonna have to put on my I didn't think I was gonna have to put on my different voices for my theater today. But that's what happened. I just was reading the document. As soon as I pulled it up, I read the first page. That was it. So I knew it was a little slickness in it. So I was like, oh, this gonna be good. But I didn't know he had all these excerpts in here until we got to him. But thank you, guys. And that's how that was his grand finale. Because now we have, for the reasons set forth above, the court should deny the defendant's motion for imposition of a gag order in its entirety. The defendant's motion cites to no law. It alleges no relevant facts, and the requested order is entirely unconstitutional. Prior restraints on free speech and free press are, quote, the most serious and the least tolerable infringement on First Amendment rights. And the defendant fails to provide any basis in law upon which the court could authorize such an infringement. He requests a gag order that is far broader in scope than a similar order struck down as unconstitutional by the Supreme Court of Georgia and that WXIA TV case, but the decision of the Supreme Courts are binding decisional law in all other Georgia courts. And then it has a parens, the decision of the Supreme Court shall bind all other courts as precedent. So basically, any decision of the Supreme Court is binding on all of the lower courts. So that's your appellate court, your immediate appellate court, and also your trial court and your district. Well, we have district courts. I don't know what they call them there, but that is that. So they said that WXIA case is what should apply. So he's showing the email. And when he was sending the press release, this was his press release, and he sent it to Jeff. He said, Jeff, this is the case we indicted on Tuesday, where defendant is a strange husband of Steve Harvey show co-host Shirley Strawberry, attaching a presser below that I drafted. Y'all feel free to edit the quotes as you see appropriate. The body of the presser is largely pulled from the indictment itself. So if possible, please give me a heads up if anything there needs to be changed. Want to make sure it doesn't include anything that not in the indictment itself. And that's from WW. So he said before he did press releases, he went and got second opinions. So let me see what's the next exhibit. Okay, that was the same thing. Oh, that's it. Let's read the press release right quick. Let's see. Fulton County DA Fonnie Willis announces indictment of Ernest Williams in decade-long $1 million RICO fraud scheme. On April 23rd, 2024, a Fulton County grand jury indicted Ernest Williams, a.k.a. Nesto, and Erica King in a 39-count indictment for numerous theft and fraud crimes, including violation of the Georgia RICO Act, false swearing, filing false documents, bigamy, theft by taking, conspiracy to commit unauthorized practice of law, identity fraud, false statements and writings, theft of services, and deposit account fraud. As part of the RICO scheme alleged in the indictment, Williams is accused of knowingly entering into a fraudulent marriage with longtime radio show host Shirley Strawberry, who is not charged with any crime, and using the void marriage and the high-profile celebrity connections he made because of the void marriage and furtherance of other frauds perpetrated on unsuspecting individuals, businesses, and governmental entities. As alleged in the indictment, Williams is charged with stealing United States currency, personal vehicles, motorcycles, coach buses, trailers, automobile parts, and other various services and property with an aggregate value of nearly $1 million, often by falsely promising to help his victims engage in business ventures or to help them build their brand or image. In addition to numerous thefts as part of the RICO scheme alleged in the indictment, Williams solicited co-defendant Erica King to steal the identities of multiple attorneys licensed to practice law in Georgia, to impersonate those attorneys in discussion with law enforcement officers and in court filings, and to appear in court and falsely and fraudulently represent Williams in hearings before multiple Fulton County Magistrate Court judges. The Fulton County District Attorney Office White Collar Crime Unit conducted an 18-month investigation that led to the indictment in collaboration with the Roswell Police Department, Sandy Springs Police Department, City of South Fulton Police Department, and other agencies in Georgia and in California, and by working directly with victims of Williams and King's crime. So sounds like it wasn't just Roswell. Sounds like they had other police departments, even though Roswell seems to be, the focus that people are focusing on. Members of the public who believe they may also be victims of Williams related to this scheme are encouraged immediately to contact the Fulton County DA's office. It gives their email. Since day one of my administration, I have instructed my staff to put Fulton County citizens first in every case and to demand that justice is delivered on behalf of all victims in this county, whether we are dealing with violence or financial crimes. I am pleased that the grand jury agrees that financial crimes such as the ones charged in this indictment are extremely serious. Serial scammers will not go unpunished in Fulton County, said Fulton County District Attorney Fonnie Willis. Protecting Fulton County citizens against fraud and other financial crimes is the heart of the White Collar Crime Unit's mission. These crimes cause years of financial ruins, sometimes wiping out a victim's entire life, saving savings overnight. We believe every victim deserves to have their day in court, and we look forward to aggressively seeking justice for anyone victimized by Ernest Williams and his co-conspirators, said White Collar Crime Unit Deputy D.A. Will Wooten. Defendants charged by a grand jury are presumed innocent until proven guilty beyond a reasonable doubt in the court of law. Let me see if they took anything out of here. I don't know. I don't know if they changed anything. It looked a little shorter, right? Did they take some of that stuff out? Maybe not. And that is that, guys. That is it. That is the response from the state has responded and basically said, you want us to stop talking. You haven't stopped talking. It's a prior restraint. It's unconstitutional, and you don't have any laws to back up what you're asking. So therefore, court, we ask that you would deny it. And then the court decided to put specifics that I think they came to make sure that it was known that what the state did was not outside of the purview of the rules of professional responsibility, which we all have to abide by in our various states when it comes to making statements. And because Ernest Williams decided to do this interview and put all these statements out here, even though, the video had like 11,000 views or whatever, there were statements that the DA said they have the right to respond to because they allow them to do that under the professional rules of responsibility. So they basically justified whatever. And they only came out with, it looks like, that press release and then also the video that we saw. So there's that, guys. DJ said I'm backing up his pettiness. Am I? Do I sound like I'm not trying to back up pettiness? I was just reading the steps. I was trying to summarize it. Because it's a lot of legal jargon, and that's why people come over here. So when I'm sitting here thinking, it's because I'm trying to make sure if I was explaining this to someone that has never known anything about the law, how will I explain it? So that's a lot of what I'm doing when I'm like thinking, so that I can make sure that I relay it in a way that's understandable, so you get what I'm saying. Because oftentimes too, I'll say words and I'll keep saying it. Like when I said prior restraint or sequestration, usually I'll just keep talking because to me, that's like everyday normal language now, but it may not be everyday normal language for you. So that's all. I wasn't trying to be petty at all. That's it. That's it. But that's all, guys. Thank you guys so much for rocking with me. You guys showed out today. I appreciate every Cash App, every super chat, every super sticker. I appreciate it. Tanya, thank you so much for the super chat. A friend Drew and Crawford said instead of being like Job, he should have been like Jesus and not said a mumbling word. Oh my God. Thank you for the super chat, but that was sound advice. I think that was wisdom. 504 says, shout out to Fonnie. I can't get Young Thug, so I'm going to get Nestor Willis. You know what? Let me get off here before they think that what you guys saying, I'm adopting. You know what I'm saying? I still need to go in these courts and be able to deliver this information to you guys. And I have to, be professional when I do this. You know what I'm saying? You guys make it really, really hard for me sometimes because I'm a human being. Some people are like, you're a lawyer and you talk like that and you do that. I am a human being. I don't go to court and say, what up, though, judge? Like for real, though, and start doing it and going a bunch of languages. I don't do that. I act professional in court, okay? This is us kicking it on the channel. I need you guys to differentiate between the two. You know what I'm saying? And thank you guys so much. Codename Nikki said, we need you safe out here. Yes, yes, yes. Hopefully I'll be back on tomorrow. So you guys be looking out and I should have, whatever information happens with Jen and them on tomorrow. You show right said I hope he does better than Miss Love and her team. They over there struggling. They are definitely on the struggle bus. But that's what happens when you deal with this type of case. It's oftentimes it's very, very difficult. They'll plea out and then make things as hard as possible because people don't want to look like snitches. It's very difficult to even, this is not uncommon what they're going through. I'm sure they have cases where they've done so much better as the prosecutor and looked so much better. Thank you, April B, for the super sticker. I appreciate you guys so much. Make sure you hit that like button on the way out. Hope you guys enjoyed the content because I definitely enjoyed you guys. But until next time, I'll holler at you guys later. I'll see you guys in the comments in the YouTube streets, I'm sure. Talk to you guys hopefully tomorrow.